everyone, and welcome to the second podcast in our series on AML regulation applicable to registered AIFMs. My name is Evelyn Marr and I am partner and head of the investment management department at BSP. And I am joined here again today by my colleague Christoforos Soteriou. Hi Chris, and welcome back.
Hi Evelyn, thanks for having me.
Last time we spoke about how registered AIFMs were fully in scope of the AML regulation and what type of governance arrangements needed to be in place to fully comply with the rules. We spoke about the role of the RR, the person responsible for compliance of the AIFM's AML obligations, and the RC, the person in charge of the control of the AIFM's compliance with AML obligations. Today we're going to look more closely at the risk-based analysis that an AIFM has to carry out and the extent to which certain of the AML functions can be outsourced. So Chris, the last time we spoke you mentioned that the AIFMs should do a risk-based analysis of their activities prior to managing any investment fund or entering into any type of business relationship whatsoever. What exactly do we mean by this?
Well, registered AIFMs shall first, prior to managing a fund or entering into a business relationship, take appropriate steps to identify, assess, and understand the risk of money laundering and terrorist financing that they will face. In taking those steps, they will need to take into account various risk factors. For example, what risks do the investors themselves pose? Are there countries or geographic areas that they come from high-risk areas from a money laundering perspective, for example? What type of investments will the fund make? Are those investments being made in high-risk countries? Are intermediaries to be used? Who will the fund transact with in terms of service providers? Where are they located? Who owns them? Are they regulated? This is not an exhaustive list of the risk considerations that they need to be taken into account, but definitely a good starting point for undertaking an initial risk-based analysis of an AIFM's future business activities.
And how would the AIFM document that it has performed this risk analysis?
Such analysis should be documented in writing. This could be done by the RC, for example. Once it has been carried out, it should be approved by the Board of Managers of the AIFM. So it could either be documented in the board minutes itself, for example, or attached as a separate document to the board minutes.
And is it possible for the CSSF to request evidence of the AIFM having done such a risk-based analysis?
Yes, the CSSF could possibly request evidence that this has been carried out. Each year, the CSSF issues an AML questionnaire to registered AIFMs. What we have seen is that the CSSF, in follow to such questionnaire, may ask for the provision of information on such AIFM's risk-based assessment of its activities.
And what exactly is the benefit of carrying out this risk-based analysis?
Such proactive analysis can assist AIFMs to fully understand the risk of money laundering and terrorist financing that may emanate from their activities and allow them to implement tailored policies and procedures to tackle those risks in a structured way in compliance with the relevant rules.
Where can AIFMs draw examples or guidance from in order to help them to draw up this analysis?
To start with, in terms of guidance, the European Commission have issued a supranational report on the risks of money laundering and terrorist financing, which is available on the European Commission's official website. This report is very useful as it assesses the vulnerability of financial products and services to the risk of money laundering and terrorist financing. It is conceived as a key tool for identifying, analyzing, and managing or mitigating money laundering and terrorist financing risks. In addition, we have the three European supervisory authorities, ESMA, the European Banking Authority, and the European Insurance and Occupational Pensions Authority, that they have issued joint guidelines which specify how professionals, such as registered AIFMs, can adjust anti-money laundering and counter-terrorist financing customer due diligence measures, depending on the level of risk associated with a business relationship or occasional transaction. Also, they set out examples of due diligence measures, either simplified for lower risk or enhanced in order to mitigate higher identified risks. There are also some useful local documents such as the CSSF's Money Laundering and Terrorist Financing Subsector Risk Assessment. It was issued, if not mistaken, in January 2020. And the National Risk Assessment of Money Laundering and Terrorist Financing, published by the Luxembourg Ministry of Justice, again in 2020 September, which provide very helpful case studies.
We talked about the AIFM's analysis of the various different AML risks that they may face. With regard to investors in particular, how do AIFMs specifically assess the anti-money laundering risks which they may be facing?
When an investor wants to subscribe to a fund managed by the AIFM has to assess such investor and categorize them as high risk, low risk, or normal risk. This has to happen before the investor is accepted into the fund. The relevant risk level will be decided by the AIFM, applying a consistent combination of risk factors to such investor situation. For example, is the investor domiciled in a country that is recognized as being high risk from an AML perspective? Is the investor a listed entity? Is there transparency around the beneficial ownership of this investor? Or is there transparency as to where these investor funds are coming from? There are annexes as well to the AML law which list factors that can be used as evidence of potentially higher or potentially lower risk. Once an investor has been categorized as mentioned, then this will dictate the level of due diligence that needs to be carried out on such investor. The higher the risk, the more enhanced due diligence is required. In any event, the AIFM shall perform periodic assessments on the investors to make sure that the initial risk scoring allocated to them at the beginning has not changed since then. If subsequent to such assessment the risk is considered to have changed, then the relevant KYC checks should be adjusted.
And what difference is there if you have an intermediary subscribing to a fund managed by the AIFM, the intermediary subscribing on behalf of the ultimate investors?
Where the fund under the management of the AIFM is subscribed through an intermediary acting on behalf of others, the AIFM shall put in place enhanced customer due diligence measures for this intermediary in order to ensure that all the obligations under the AML law are complied with. What this means in practice is that the AIFM will need to carry out a due diligence on the intermediary itself. That means that the persons purporting to act on its behalf and its beneficial owners shall be identified and their identity verified, applying the same risk-based approach that we just spoke about. It also means that the AIFM will need to investigate the business relationship with the intermediary, meaning that the AIFM should understand the nature of the business relationship between the intermediary and the underlying investor per se. For example, is the intermediary acting as a nominee? Is it a depository bank, etc.?
Thank you, Chris. So, we've learned an AIFM has to carry out an analysis of the risks it might face, and then, as it is faced with new investors and new intermediaries, it needs to apply that analysis to the specific situations it's facing and the particular investors that are subscribing to the funds it manages. Once it has assessed the risk level, it then needs to get down to the nitty-gritty of carrying out the due diligence checks. If the AIFM is using third parties to carry out these checks, for example, the fund's central administrator, is the relationship with such third parties also subject to the risk assessment?
Yes, absolutely. The AIFM will have to assess and identify any money laundering risk which may emanate from their business relationship with such third party, and indeed any other third parties that may enter into a business relationship with. It is also important to know that the liability for complying with the AML obligations is not shifted to such service provider, but instead the AIFM remains always liable to ensure that its obligations under the AML law are complied with.
And are there any eligibility criteria for service providers assisting AIFMs in their AML checks?
The AIFM may only outsource this activity to certain entities, to other professions which are subject to the AML law, such as banks, professionals of the financial sector, or other institutions or persons situated in a member state or third country, which apply customer due diligence requirements and record-keeping requirements that are consistent or equivalent with those laid down in the AML law, and are supervised in a manner consistent with the AML law.
Are there other matters to bear in mind when relying on third parties to carry out your AML checks?
Yes, there are a few other things that should be borne in mind. It is for the AIFM to assess if a member state or a third country imposes obligations which are equivalent to those laid down in the AML law, and the reasons for concluding that a member state or a third country imposes equivalent obligations shall be documented when the decision is taken by the AIFM. In doing so, the AIFM can take into account guidance given by the Financial Action Task Force, FATF, on countries which are considered as applying lower or weaker measures for combating money laundering and terrorist financing. This report can be found on the FATF's official website. The conclusion that a member state or a third country imposes obligations which are equivalent to those laid down in the AML law does not relieve, though, the AIFM from carrying out its own risk assessment on the efficacy of such countries in combating money laundering and terrorist financing. The obligations imposed by a member state of the European Union shall be considered equivalent, except if there is specific information available which says otherwise. Lastly, I will say that it's also prohibited for the AIFM to rely on third parties established in high-risk countries as deemed by the same AIFM, as well by reports prepared by international organizations such as the FATF, unless such third parties are branches and majority-owned subsidiaries of the AIFM.
Thank you, Chris. So the AIFM can use third parties to carry out the checks, but it has to be careful who it uses. I think that's what we can conclude from what you've said. Okay, so that's all we have time for today. If you have any questions or queries on what we've just spoken about, please don't hesitate to contact either Chris or myself, and you can find our contact details on our website, www.bsp.lu. Thank you again for listening, and we hope that you join us at our next podcast.